Hello, everyone, and welcome to today's latest Fenwick Elliott webinar. My name is Stacey Sinclair, and it is wonderful to have so many of you with us here today. Thank you for joining. So today's session, of course, is about the new Building Safety Bill, which was published on the 5th of July. The bill has been updated since it was first published in draft form last year. And we're here today to discuss what has changed and what this potential piece of legislation means for the construction industry. And to do so, I'm honored to be joined by two very distinguished construction lawyers who probably need no introduction, but very briefly. Firstly, we have Fenwick Elliott's Simon Tolson, a regular here on our Thursday sessions. In addition to being our senior partner, Simon is ranked amongst the top construction solicitors in Chambers UK and Legal 500, and is a past chairman of the Technology and Construction Solicitors Association. Excuse me. And joining Simon, we are delighted to have with us Mr. Paul Darling QC, barrister of 39 Essex Chambers, whose long list of achievements includes being awarded an OBE in 2015, former head of Keating Chambers, and in case many of you may not have heard, most recently, he has celebrated the publication of the 4th edition of Wilmot Smith on Construction Contracts, of which he is now the co-editor. Welcome, Paul. Both Paul and Simon, of course, specialize in construction engineering and energy projects and disputes, and of course, issues relating to cladding and building safety. Now, before I hand over to our eminent experts, the usual housekeeping. You will all be on mute, but please do submit questions as we go. You should see the questions box on the right-hand side of your screen. And at the end, I will put as many possible questions to Paul and Simon anonymously. We do have a full agenda today, so we may well be more on the 50 minutes rather than 40 minutes that we normally promise. But rest assured, the slides and a recording of this session will be on our website in due course. And I believe you should see a link to where you will find that in the chat box as well. So without further delay, Simon, I believe over to you.
Okay. Yes, thank you very much, Stacey. That's helpful. Yes, if I can click the first slide and make sure that technology works. That's besides having a little interesting image that looks almost 19th century in relation to the bill and some key clauses. Really what I want to get to is this slide. We are, as Stacey indicated, covering quite a few areas today, and we don't want to disappoint many of you, but obviously it's impossible to cover over 200 pages of bill and draft regulations in the best part of 50 minutes. But the areas that we want to address are these 10 on the slide. So we're going to cover background, what's new, what's come out, because there's some interesting things on that. Paul's going to be looking at what it means for developers and contractors, what it means for leaseholders, some of the insurance applications, some of the nuancy things to do with insurance, which I think are pretty important to everyone. I'll touch on the Human Rights Act as well in relation to its relevance to this bill. Safety cases and the golden thread, which we could and probably will have a separate program on in its entirety later on in the year, the building safety regulator, and something about the new construction projects regime, and then the transition for the period when this bill hopefully will come onto the statute books next year. So without more ado, over to you, Paul.
Thank you very much indeed, Simon. I got to try and make sure I can make the slides move. I will be going through this at quite a canter. The slides the excellent slides that have been prepared by Fenwick Elliott go through all the issues that arise here very carefully and in great detail. I'm going to be going through the topics, picking out the important points. I'm not going to be taking you through the slides line by line because we trespass on eternity, never mind run out of time if we did that. But we're going to pick up the big points as we go through. First point to make is the latest version of this bill was published on the 5th of July. It's the bill that's going through Parliament. It's 218 pages. I hold up a sort of, copy of a printout of it. That itself tells you a great deal about what's being done. 257 pages of explanatory notes, various regulations. Had the first and second readings, we're now at the committee stage. Lengthy process, serious ramifications for this industry. and for construction lawyers. There'll be royal assent in 9 to 12 months, it's thought, but after that there'll be a raft of secondary legislation, regulations, etc., to fill in the details. The government has lofty ambitions for this bill. They were on the slide. They were set out on the slide that I just managed to go past. The reforms are, and what the government says is, I'll read it, to create lasting generational change and a clear pathway for the future on how residential buildings should be constructed and maintained. That is a lofty, oh yes, thank you very much, lofty attempt to set out the clear objectives. But I don't think it's impossible to understate. This is, to use a technical term, big potatoes. This is a massive and detailed, it's a big reform, but it's also a very detailed reform. And it is, in my view, going to just change the face of a lot of what we do. It comes out of the Grenfell crisis, and that, of course, revealed that the system for building regulation was wholly unfit for purpose. We know that the inquiry is now in the end of the second module, but the government hasn't waited for that. It's listened to what Dame Judith Hackett said, who gave evidence to Grenfell, and her report made 53 recommendations, which provide the core of this bill. If I can then, this slide deals with the background. The key point is that prior to Grenfell, we've been living in an era of deregulation. Basically, Grenfell and other recent events have completely changed this. Now, this partly fits with the way in which the world has moved. There was a lot of deregulation, and people now start to re-regulate. But if I may say so, this is absolutely key to the industry to take on board, that it is now going to be much more heavily regulated. If I move on to the next slide, the bill is primarily aimed at residential buildings located in England. But it is important to remember that it covers all buildings and not just high-rise residential. Some obligations come into force sooner. Gateway 1 process will come into force on August the 1st this year. Various amendments made to the planning system so as to better incorporate fire safety concerns at the planning stage for schemes involving high-rise residential buildings. The Queen's speech introduced the bill, and if you look at the government's approach, my ministers will establish law in a building safety regulator to ensure the tragedies of the past are never repeated. Government described the reform's biggest changes to building safety regulation in a generation, clear pathway to how buildings should be constructed and maintained. But the London Cladding Action Group says, gulf between the government's rhetoric that developers must pay and action to ensure they do remains too wide. So controversy there, but the government's objective is certainly large and extreme. This slide sets out the basic structure of the bill. It will impose considerable new liability via amendment to the Defective Premises Act. And dropping down the slide, government's focus on a new building safety regulator remains to ensure that no dangerous materials are incorporated in the construction industry, are used in the construction industry or incorporated under buildings. The bill also introduces a retrospective extension of time in which residents can seek compensation for what's called substandard construction work from years 6 to 15. The rhetoric implies this will introduce a right which residents alone will be entitled to use, but the provisions of the bill go further. We then have the structure of the bill, 6 areas: overview, part 2, building safety regulator, part 3, amendments to the Building Act, new regime in relation to higher risk buildings, role that the new regulator will have. Worth noting here that higher risk buildings are in England, a building that's either, and we all know the magic number, 18 meters in height or has at least 7 stories, or of a description specified in regulations which the Secretary of State is empowered to make, picking up the theme that there are going to be regulations that will develop and expand this. Part 4 deals with higher risk residential buildings in England only once they're occupied, certain duties on duty holder in occupation in relation to safety. Part 5 is catch-all, but it deals with service charges, including the controversial building service charge and regulations for the regulation of construction products. And Part 6 deals mainly with technical matters. But the key thing is, when you start to look at that, this is a very meaty bill. And in fact, the more, when you delve into an individual section, there is more and more meat. I reflected with Simon when we started, before we started this, you look at the Defective Premises Act and you get that into 3 pages or thereabouts. Depends on the size of the page, obviously, but nevertheless, the volume and detail across the board, but also with the independent items, the independent subsections, is a very heavy process. Key point: although the limitation changes have retrospective effect, this will only reach 15 years. Constructions prior to 2007, 2008, depending upon the date of royal assent or the date of operation of the Act, will not be affected. So the important thing to recognise is that there is not going to be liability for buildings constructed before that date, but the other side of that coin is that buildings where it might have been thought that liability had now run out, that is not going to be the case, and you're going to see this tail reasserting itself. So what is new about the Act? Current regime, claimants have a 6-year limitation period from completion to bring from completion of the dwelling to bring a claim under the Defective Premises Act. It's 6 years from completion. That means that many potential claimants were time barred from making a claim under the DPA because the works in question were completed so long ago. The fire safety failings will make dwellings unfit for habitation. The Rendlesham decision, which refers to you need to be able to occupy a dwelling for a reasonable period of time without significant risk to the health and safety of the occupant, has that effect. So the proposed change in time will have both retrospective and prospective effect, which means that there'll be all ongoing claims and will resurrect some that have previously expired. Simon and I were discussing before we started, there is another potential right of recovery in negligence, which did already have a longer limitation period, but it is generally, and perhaps even stronger than that, not possible for a homeowner to succeed with a negligence claim against developers because of the legal principles about you can only recover damage to other property and you can't recover pure economic loss. So the effect of this is to extend the limitation period in the one area that it is that homeowners in reality have historically had a viable remedy, particularly if they were second purchasers. The important point to take on board is that if you look at the limitation period, you will see that what this means is that people that would not have claims now have claims. People who previously had claims which have become time barred will not now will now have the ability to continue. Now, from a contractor's point of view, it is important to note that that the work has to be done in a workmanlike, or as the case may be, professional manner with proper materials, so that as regards that work, the dwelling will be fit for habitation when completed. Now, that is essentially, and we can have a whole separate seminar on what the extent and nature of that duty is. But in reality, it essentially imposes strict obligations upon the contractor. The limitation period means that requirement now has specific force. Now, what this means is that there's an extra 9 years to bring a claim under the Defective Premises Act. Absolutely key to understand the breadth and extent of that extension. There are more extensions coming in a second, but that is going to mean that people have a much longer liability, even than if they'd had a 12-year liability because of a contract under deed. But it doesn't stop there, because the bill also is going to extend the reach of the Defective Premises Act, and depending upon how you construe the wording, going to mean that it applies to extensions and to other works carried on buildings. So you've got extension of the duty and you've got a longer limitation period. You also have coming into force, potentially even more significantly, a Section 38 of the Building Act 1984. That's been there since then, and construction law commentators, including in my case the late great Donald Keating, who was fascinated by this provision, enabling people to claim compensation for breach of the building regulations, it being thought that without such a provision, breach of a statutory duty didn't give rise to an entitlement to claim damages. So the Act envisages, it doesn't do it, but it envisages bringing into force Section 38 of the Building Act 1984, giving people the opportunity to sue those who've constructed buildings in a defective manner, independent of their contractual rights. And the double whammy here is that, again, the 15-year limitation period is going to apply, it appears, to that section of the Building Act. So alongside the Defective Premises Act, you've got the now building regulations damages right brought in by the Building Act 1984 being activated, and essentially that is going to mean that you get that contractors are going to be caught by a twin track, an improved Defective Premises Act claim for homeowners, a new building regulations claim, both of them with a limitation period of 15 years, which in the case of the DPA extends it by 9 years. So from the contracting point of view, one is seeing a pretty significant shift in liability from the in favor of the homeowner, building owner, as against the contractor. There are amendments also in relation to service charges in respect of remediation work. One of the new provisions being inserted, Section 124, landlords cannot automatically recover the cost. Instead, they've got to take reasonable steps to obtain monies either from available grants or from pursuing third parties before pushing remediation costs onto homeowners. And that one's a bit more pro-contractor or pro-industry, because it simply requires it simply requires them to pursue available remedies rather than stopping them from making the charge. Be interesting to see how all of that works. And of course, that limit on leaseholders' benefits and entitlements is going to be of particular significance and harm to those whose houses, cladding dwellings were completed before 2007. Robert Jenrick has said that the majority of developments with defective cladding were built between 2000 and 2017. So you could exclude about 33 or even more of that, of the developments where there are problems, because they wouldn't have the benefit of the extended limitation periods, etc. My view is that the effect of this is probably quite modest, because in practice, service charge leviers were always interested in who it is that they can recover monies from. but it does mean that there are, in my view, likely to be materially more claims coming in to the system than was there before. It's worth just having a word about what in the various iterations of the bill, what is not now happening, but there's so much to worry about what is happening. I'll take this very quickly. Here we go. The building safety charge has, I just discussed the way in which that worked in the current bit, but that the change there, which might be thought to be anti-leaseholders, but the bill will only allow, so you see there set out in the slide the individual effects of it. Previous versions of the bill allowed building owners to charge for historical building safety costs, even for defects which predated residents moving in. The Select Committee recommended this be amended to exclude historical charges. So the bill has accepted that and will only allow building owners to use the building safety charge to cover ongoing costs of new regulatory regime created by the bill. If you then, entirely omitted from the bill is any reference to the loan scheme for buildings under 18 metres. The government's plan in February 2021 was to introduce long-term loans for leaseholders facing bill to replace cladding on buildings under 18 metres tall, whereby no leaseholder would ever pay more than £50 a month towards removal of unsafe cladding. That has gone from the gone completely from the new version. There's some recommendations of the Select Committee that were not taken up, and we set them out there. We then suggest that blocks between 11 and 18 metres are left in limbo. For cladding removal of blocks between 11 and 18 metres, the government said on the 10th of February, and it referred to the charge I just mentioned, there is no provision for that in the bill that is presented to Parliament. Click onto that. Another key omission is any sustained attention to what happens for leaseholders in unsafe buildings which don't fall into the higher risk category. Regulations will get in regulations what higher risk means. It could be broad, but giving more people protections of the Act. But inevitably there will be schemes, there will be situations not covered. Nor does it deal with what might be thought to be the real commercial problem, which is the difficulty of enforcing and suing people that long ago in circumstances where insurance has expired or they have been SPVs. Now, the reality of that is that may be going to prove, as all of you will, I'm sure, recognise, to be a potentially big problem. It's all very well allowing you to sue someone for 15 years, but if they ain't there, gone bust, or haven't got insurance, then that right is going to be more theoretical than you might imagine. And we then move on to what it means for developers and contractors. Here, Simon and I segue in. I'm going to just take a minute before Simon takes over to just take a step back. To my mind, we've hit a very interesting, and when one talks about things being interesting when they're as serious as this, I know people smile, a very new situation. In the 1960s, 70s and 80s, there were massive defects actions for buildings because of the existence of claims in tort and poor building. And the reality was that building standards have improved, so the sort of widespread defects that we saw in those days have diminished, further diminished by the fact that claims in negligence were removed by the law being clarified in Bates, Murphy and DNF estates. You've then seen the industry reacting to that with the cladding problem, which has brought things to a dramatic head and exposed a regulatory system that has been shown to have great difficulties. What that's then led to is very considerable government intervention, which one extends and makes more powerful rights that already exist under law, but secondly imposes very considerable detailed regulatory requirements. And thirdly, both of them are done in highly complex ways. It shifted the risk away from consumers to the contracting side, and within the contracting side, in my view, has placed considerable risk upon the contracting part of the supply chain. So it's a very complex bill. I know it's a quick whistle-stop tour, and I now hand over to Simon, who will take you through the practical implications.
Thank you very much, Paul. Right, well, there are many implications for contractors and for all of those involved in the building and construction and procurement of construction. Oh, don't know what happened then, but I'm sorry, apologies for I didn't touch the screen and it jumped about 20 slides. Yes, I was on that slide. So basically, house builders will bear the brunt of the changes, and that basically means the contractors. There are many practical implications for potential defendants of these changes, and obviously Paul has been discussing just now the effect of these changes in relation to the Defective Premises Act and the bringing into force of Section 38 of the Building Act 1984. And obviously that's changing things significantly in terms of the existing limitation periods for those types of remedies, one of which will be wholly new. And the extent to which contractors are exposed is obviously a serious concern for those that are involved. And there are going to be literally thousands and thousands of companies up and down the country, which since the publication of this bill on the 5th of July, are doing audits and reviewing their contractual arrangements on historic legacy contracts, some of which they had consigned to storage on the basis they're outside limitation and will have to be reviewed. I've said on the second point there, defending some claims is going to be darn sight harder to defend. And obviously the realism really in relation to many construction projects, as most of you know, there's a lot of mobility of labour in the industry because of things like that wonderful creature, the GDPR. We've been very hot since 2018 on policy for destroying documentation and data when it basically contains information and personal data and so forth. And a lot of companies have been rigorous in relation to that obligation. And what that means is that because of this change in limitation, a lot of companies are now potentially going to be deprived of access to documents, and whether they're electronic or paper-based, in which to defend themselves. So that's a kind of practical repercussion. So a big change in potential liability for claims. And I've said there, it seems inconceivable that a human rights challenge could be relevant in terms of this legislation. But it's interesting that the bill has provided some protection for contractors and developers in relation to whether they can squeeze themselves through the cracks of basically having potentially an unsafe or unfair trial in relation to proceedings that are brought against them. And so I'll see in a couple of slides time, but when you have a chance to look at these slides when we upload them, you'll see it's expanded on a little bit further. Implications continuing in terms of contractors and developers. Obviously, there's the potential for difficulties in bringing claims. You've got the situation Paul was referring to about the delta between the 12 years and the 15 years that's going to come in. There are going to be situations where contractors aren't able to pursue suppliers or specialist subcontractors in circumstances where they're outside the normal limitation periods of, well, certainly 6 years or 12 years for deeds. So limitation of contract, deed obviously shorter than the 15 years. So if limitation for the agreement with a third party at fault, that's going to be a cause of trouble, because there may well be no remedies available to parties that are successfully suited, which again is going to cause, I mean, you won't see the sort of violins coming out for contractors maybe, but it's going to cause a significant, I think, shakedown and there are going to be obviously insurance implications. And a statute that's not used a great deal, although seen quite a bit in the TCC over the last 4 or 5 years, is the Civil Liability Contribution Act of 1978. Now, that allows an entity to bring proceedings, in fact, after up to 2 years after a successful action brought against them, to seek a contribution or an indemnity. And there are articles already being written by solicitors at the moment and lawyers around the country on re-enlivening effectively their knowledge of the Civil Liability Contributions Act for possible routes to claw back, on the basis that we're going to see more parties involved in these cases with the litigation that comes with it. So I've said here that even if possible contribution claims are likely to be difficult because of the insurance coverage issues, Paul again alluded to the fact that cover may simply not be available. Obviously, entities may have gone out of business, which makes the obvious point: no one to sue, and there's no legal process in the world will get blood out of a stone in those circumstances. And I've said there, it will be the case that contracting with third parties in the future will require developers and contractors, if they're on D&Bs, to be aware of these changes to ensure subcontractors and other relevant parties, specialist designers, etc., are on the hook for longer periods contractually. And in my firm already, we're looking at amending contracts and appointments to provide for this, and that won't be unique amongst law firms at this point. In terms of implications for developers, the point about the Defective Premises Act, which interestingly, as many of you know, it hardly had any shows in the courts of this country for many years after coming on the statute books in '72, and only really started to grow some arms and legs in about 2003. And we've obviously had, with the Rendlesham and Barr case in the TCC, a resurrection of the DPA as a potential route or remedy for parties that don't have a contractual nexus with the alleged culpable party. So I've said there, developers may face renewed claims from subsequent purchasers following upon freehold sales. So that means if you acquire obviously an interest in the building at a later date, you may well have a cause of action under Section 1 against the original parties who were responsible for the design and or construction or materials that went into the building. So it's this whole concept of being involved in the provision of a dwelling and uninhabitability and fire being a prima facie case of making out that basis are all concerns for the construction community. What does it mean for leaseholders? This as a subject could occupy us for a considerable period, and there's a lot of lobbying and pressure groups that are very uncomfortable with what the bill has said or not said. And as Paul was alluding to, there are various things not included or not elucidated that had perhaps been expected given the consultation following the July bill of last year. So very quickly, just going through this, I've said there at the top, it's not the long anticipated solution that many leaseholders wanted. So the government's offering to leaseholders the key ones to be aware of, and I'm sure most of you are on this webinar aware of, clause 124 requiring landlords to take reasonable steps to recover money before billing leaseholders in relation to seeking recovery for costs of modifying or altering the building to make sure it complies with the new, current, updated 2010 building regulations, etc. And clauses 125 and 126, which again we've touched on a number of times in the context of the 15-year retrospective limitation period to claim for, as Paul again stressed, substandard work and what that brings within its meaning and effect of those words. Whilst this is an improvement on the existing framework, again, the government is effectively giving to individuals, to housing associations, to litigants, the possibility, increased a possibility of actually raking over past calls, which they thought may not have got them anywhere with the these new causes of action that are available. So it's not as if that there is a question of incomplete balance in relation to leaseholders, but obviously there are the problems with whether, and they're public policy questions more than anything else, whether government steps in and actually funds the correction of defects in high-rise buildings, and the question about particularly those buildings of between, say, 11 and 18 meters, which fall between the Devil and the Deep Blue Sea potentially. So significant proposals, a significant proposal, yes, but a number of practical problems for parties, which are already being, as I say, addressed in construction material and journals. Right. Now the next slide is it's not the long anticipated solution, which I think I've really kind of basically been covering in Paul's address, so I won't say too much more about that. Yeah, insurance implications. The situation with regard to coverage and particularly professional indemnity insurance has become pretty dire, as most of you are aware, in terms of both the availability in the marketplace of insurers that are able to offer cover, which contractors from any side, you know, general building contractors, those doing residential work, and obviously within the major infrastructure projects up and down the country, where obviously such coverage again is essential and often contractually a requirement to hold if you're actually going to even get yourself onto a tender list to actually bid for work. And really what Grenfell has done in what was already a hard market impacted by a whole conglomeration of things, including the credit crisis in 2008-9, but a number of other issues. And in fact, to be honest, things like aviation, you know, engines, aero engines, and failures there have actually had an effect on the PI market as well. And Lloyd's of London running a survey about 2 years ago, I recall, basically saying that PI coverage business in the construction industry was the least profitable, in fact, generally not profitable area for underwriters to be writing business. So the market and Grenfell have kind of come together at a point which is extremely inconvenient for those seeking to basically get cover. So but what I'm saying there is it's difficult, it's costly for professionals to get cover. A lot of companies, a lot of consultants are not able to carry out certain aspects of their professional service, or contractors even undertake certain types of projects where their coverage is restricted, because in order to carry some cover, they are having to limit the ambit of their work in many areas. In addition to which, the availability of cover, and obviously £10 million and less is the lion's share of the market, is becoming still very hard to get at sensible rates. And I think this year I read that rates are somewhere between 3 and 4 times what they were last year, and last year had doubled on the year prior to that. So we're seeing sort of exponential increases there. I mentioned in the next bullet point down there, expect to see an increase in cases where the term fitness for habitation under Section 1 of the DPA is considered by the courts. Again, that's an obvious point, but it's quite clear that these types of cases are going to go up to the Court of Appeal and potentially to the Supreme Court for some clarity in relation to the effect and the depth of where these provisions take parties, and also the aspects in which the prejudice caused by a contractor or consultant, architect, engineer are considered by the courts, and to the extent that it can be made out in relation to the Human Rights Act, for example, Section 6, that the circumstances are such that the invocation of Section 1 should not be permitted in a particular case. I think the judges are going to find that very hard in the Court of Appeal, particularly the Supreme Court, to wrestle a kind of balance between public policy again and someone having to pay for this. But obviously the construction industry quite rightly is pushing back, saying, well, you know, when the 2010 building regulations were published, when the approved documents were reviewed, when we went and obtained agromos certificates and so forth, and we consulted consultants and got advice, at that time we did all the right things, we ticked the boxes. But that may not be enough. And, you know, the public policy point again there is, well, it probably is enough, but the law is changing with this bill when it becomes an act, and it's going to be quite a serious change for the industry. Yeah, so a couple of the safeguards that I've just touched on in relation to the Human Rights Act. One thing that is useful to know, at least, it's a little bit of comfort I found when I was reading the bill, is that if a case has previously been run to court and been dismissed, but I think arguably, potentially, an adjudicator's decision, probably because it's not a court of record, might not count, but that's going to be an argument out whether it's been effectively a failed claim through an adjudication, where there's been a legal determination. But basically, if there's been a claim which has been dismissed or compromised by a contract of settlement, then that cannot be resurrected and rerun just because this bill becomes an act at some point in 2022. So that's a decent safeguard. And the point I was touching on a second ago, this business about the right to fair trial under the Human Rights Act, and that being tied to and linked to losing key personnel who one can't get access to, and more particularly the loss of all material documents that might relate to the project in relation to having to defend a case because it's being brought against them 13 or 14 years after the event. There is also, I've underlined there in bold at the bottom, an established line of case law in relation to the European Court of Human Rights, which limits the extent to which new legislation is capable of extinguishing a claim or a defence already advanced in proceedings. And so that Presos case, have a look at it. We'll probably put the citation on that when we upload this, but it's a case, it's about 25 years ago now, but it was on that very point, and it's discussed in a number of other authorities as being a point of principle, both in European law and here. Now, another key area which we have touched on in other webinars in the context of BIM and such like is the golden thread of information. And allied to that is the question about certification to occupy of basically high risk buildings, which will come with the basically the whole point type system of the gateways that are now to be applied when this becomes an act in relation to moving projects from the planning, this construction, to the completion and occupation stages. Now, I think most of you will know what the golden thread is. It's probably in every construction journal for the last 4 or 5 years that I can remember, and on numerous webinars that we've all had to endure through lockdown, where it seems to come up quite often with digital twins and such like. But it is a very important subject, and the government's basically introducing a more severe regulatory regime for buildings over 18 metres and the new 7-storey designation, whichever of those is reached first. And this new role of the or allocation of responsibility to accountable persons, or the principal accountable person for buildings within scope in terms of these higher risk buildings, have this obligation to provide to the building safety regulator the digital information that allows that body, and no doubt services like the London Fire Brigade in due course, access to information pertinent to the building, as well as access for those doing design modifications during the building life history of a particular building asset. And the information management also is part of this golden thread in terms of ensuring that the information is accurate. I guess that means things like as-built drawings actually being interrogated by various means, possibly investigative works occasionally when that's necessary. It needs to be easily understandable and so forth. So I've said at the bottom there, in occupy high-risk buildings, the golden thread of information is there to ensure building owners have to hand well-documented and accurate evidence. And I remember that certainly from the 1930s under the London Building Acts, quite a few buildings in London had within their lobbies, near the fire risers often, a openable kind of chest or panel where drawings for the building would be available to the fire brigade. But inevitably, with FM work, certainly in the 80s and 90s, I think most buildings I've come across in the last 20 years, those drawings were never present and available to fire services or M&E engineers having to sort out things. So a bit more about this, the golden thread in terms of digitization. I'll just basically say it's supposed to be a live depository, a live file, which means that it's never at the end of the journey, because buildings are always being adapted and altered, and particularly with commercial space, one will see this whole area sort of expanding, I think, in terms of the need to find a way in which to make sure the systems are updated. But it includes, where a developer might add a new story onto a block of flats, and any sort of material alteration to the building, heating systems, plant, changing certain aspects of how the building works for escape and that sort of thing, all going to have to go through a gateway process, and a process which is lodged with the building safety regulator that I'll be talking about in a moment. Right, let's try and get the next slide. Right, the building safety regulator. Now, this guy is has to have a very strong back, and obviously it's not just one person. And when I say guy, I don't mean that in the sexist way. It can be anyone of any gender. It happens to be a guy at the moment who heads up the health and safety executive, and that's Peter Baker, who's been giving quite a few interviews about the new role that he will effectively be fulfilling, and the department which he will be effectively responsible for in the capacity of a BSR. Now, there's a huge amount of recruitment that's going on, and I have to say I'm slightly jaundiced in my views as to how quickly the government is probably going to support and do the right things to make sure the HSE is fully manned up for when the bill becomes an act of parliament. We'll see. I suspect there will be a time lag on that, but it's a completely new rule, a new office. It's something that we haven't got before. I think it makes us unique in this country for having a building safety regulator at the heart of building safety, and with the two-tier system, essentially, with the higher risk buildings, which, as Paul said, can be designated to change as a class, so the appropriate minister can, at later stages in the future, add the classes of building that might be incorporated, be it sort of halls of residence of lower heights or that sort of thing. So there are a number of committees and so forth that the regulator will set up, but because of time, I won't say too much about that. Main functions of the regulator are overseeing the safety and the performance systems of all buildings, and that basically cuts across changes in building regulations, identifying emerging risks in the built environment. And remember, because we're going to modern methods of construction, the kind of juxtaposition of different materials, which in the past no one's really thought about sufficiently to understand how they might behave from a fire safety point of view, but often they're not thought about in relation to their longevity in terms of how they last over a 60-year design life of a building and that sort of thing. That's going to be coming into that side of review and maybe later regulation. Assisting and encouraging in the improvement and competence in the building environment and the built environment of basically building control professionals. I think some of you will probably know that the old AI's, I say old, but approved inspector title is going to go. There's going to be a register of building control approvers. There are going to be inspectors essentially above them who will be appointed by the building safety regulator. The days of being able to dial up your favorite approved inspector company and use them for virtually all of your business, as many main contractors have done, certainly since about 1998, is out the window. That's going to go, and one will expect, as Paul said earlier on, a huge amount of additional burden really coming from a process which at one time might have been regarded as a shoo-in in terms of getting a tick in the box there. The other new thing we've got, and again, this is at its sort of very early stages, it was only announced in January and then picked up in the bill, is the new construction projects regime. This has obviously come from the inquiry in Grenfell about the huge issues about discrepant materials, fire testing, the whole sort of disgrace of BS 8414, I think it was, on fire testing of cladding, which has exposed in very embarrassing evidence during the inquiry just what a lot of companies were not doing appropriately and potentially deceitfully. So there is a very good reason that we're going to have this national regulator. It's going to sit basically as part of the Office of Product Safety and Standards. a bit like the building safety regulator, there are going to be recruitment requirements over the next 10, 15 months to man up that office. But what it basically will mean is that this regulator will, I suspect, develop a very high level of knowledge of information on building products. It will probably buy in quite a lot of expertise from the likes of the building research establishment and Agrimont and so on to get information on products. And professional bodies like the RIBA will be able to plug into information in a way that NBS has served them to a certain extent up to now over the last 7 or 8 years, but this will be really a game-changing thing. So a lot of regulation is going to come out of that. We're going to have the identification of safety critical products, which can cause death or serious injury or can structurally be significant if the building were to fail at some point. So watch this space is really what I'd say about the that regime. And then in terms of the timetable for implementation, I've done a slide a bit later on which gives you the kind of timeline of what Parliament is helpfully indicating is going to be how this bill unfolds, and that I think is one of the this bill is in fact one of the few that is actually giving quite good I suppose markers in the sand for the industry to get ready, because Parliament recognises that so fundamental are these changes that are going to be upon us that it takes the industry some time to adjust. And obviously since Grenfell in 2017, the industry is beginning to absorb quite a lot of change in terms of building regulations and understanding liability issues. But the whole question of this bill now in its fullness with the delegated legislation that comes with it is actually an enormous task for the industry to absorb over the next 2 years. But the indications there, I say there's a transitional board which is chaired by Dame Judith Hackett, which is basically assisting with explaining the rollout. And you'll see there notable targets like spring 2022, British Standards Institution will publish standards covering the competency requirements of principal designers and principal contractors, which are not quite the same as the CDM title holders in relation to those aspects of obligations under health and safety, but not a million miles from it. Then the building safety regulator is expected to be operating at scale within 12 to 18 months of the bill receiving royal assent. So that indication already shows that 2023-24 is really the period there. And then as I say on this next bullet, the new regime for high-rise buildings and other in-scope buildings is intended to come into force similarly about 18 months after the royal assent. So certainly 2 to 3 years maybe away. And this slide here, which is on the government website, it's a little bit hard to read, I think, for you unless you're right with your nose to the screen. But what that actually does is actually give you timelines from royal assent, where my mouse is at the moment, right through the process of the various stages. So you've got things like building advisory committee established with the building safety regulator. That's going to be RA, which is royal assent plus 18 months. Quite a few things are plus 18 months, but some of them go plus 24 months in terms of things like the construction products requirements for products to be safe, for example, so that you can see initially that's going out quite a bit further. So I'll pass that slide. The bit of news last Friday on the 22nd was that those blasted EW S1 forms, which came in to, in theory, safeguard occupiers of buildings which were seen as a danger, and they were seen as a danger even though they were less than the magic 18 meters, and which has blighted a lot of people from being able to sell their properties and inhibited those who've been seeking to get mortgages to buy or get an interest in a leasehold flat. And I have to say, why would you? Because I can't see any attraction to buying leasehold, and whatever government might say, it's looking very unattractive with anything that's got other than bricks and mortar and a concrete slab at every floor. So what was interesting is last Friday they basically said you wouldn't need an EW1 form, and various banks bought into it. 2 or 3 of the leading lenders certainly announced on Friday. But this Monday, the RICS confirmed that obviously it did quite a lot of work before drafting the WS1 forms, and it's basically said, well, although the new advice to government might be there's no systemic risk of fire in smaller blocks of lower height, it doesn't completely remove by any means the fact that there are lots of buildings at, say, 9, 10, 12, 14 meters, which have got hideous issues, and for government to effectively suggest you can just wipe away EWS1 forms is not really going to cut it, and they're not advising their members to be giving advice to the effect that the whole world has become suddenly safer since last Friday. So again, this is kind of a moving area, but one that you should be obviously aware of. Sorry, my mouse is hugely sensitive.
The mouse is running away with you. Before we have the Q&A, can I just add one thing to your excellent address? On what the Court of Appeal and the Supreme Court are going to do, I think the construction industry should assume that they're going to find against them. I think the mood is so pro-consumer, and I think that both of those courts are merits-led. I can see circumstances where the one hope might be that the Building Act route comes in and they focus on that and not the Defective Premises Act, and therefore they don't worry about fitness for habitation. They're willing to knock those claims back when they think it's right, because there is this alternative route under the Building Act. But the mood ain't good.
No, the mood's not good. And I mean, there are also things about certain forms of construction. At the bottom of that slide there, I've said good timber frame construction below 18 meters and certainly below 11 meters. The industry and the timber building industry is obviously going to be lobbying government in relation to the fact that they have got a good record, despite a few spectacular fires that have been the subject of panorama and various programs.
So yeah, just thinking timber frame, panorama, bing, bing, bing.
Yeah, there is this problem, that the question of making sure that government's properly informed about what actually is capable of being produced, and obviously encouraging rather than sort of prohibiting forms of construction at certain heights between 11 and 18 meters, which could quite well be of quality. But as you say, Paul, yes, a good point about.
I'm afraid, Simon, that you and I are about to get the red card from Stacey.
Yeah.
The anxiety is almost coming down the line in a sort of beep, 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 beep.
I've stopped.
Yeah, I think I'm gonna jump in now. You guys could definitely go on for ages, but it's been a huge, fantastic, Simon and Paul, such a robust run through or canter through. Gallop. And we could keep going, couldn't we? We're just scratching the surface. But I think we're just going to take just one or two questions that I can see. We've had so many questions, so thank you to the audience for sending those in. One or two questions before we wrap up here. Simon, Paul, how does this all affect the current projects that are currently being designed under the current regulations? What's going to happen in August? What should some of our clients, consultants, designers be thinking about now?
Simon, you go first.
Well, I mean, obviously, there's going to be a huge amount of review going on. I mean, obviously, current projects, certainly since Grenfell, have been subject to obviously very different processes to those that were commissioned and commenced as live projects before Grenfell. But the effect of this bill is, and the regulation that's coming with it, is obviously going to make it necessary for a lot of what ifs and recommendations, and possibly certainly a much more cautious approach to use of materials. And tried and tested is going to be very much done on the basis of what's been established as proved and tried and tested. And that's
don't use the words value engineering or do it. Secondly, I think we're going to be in a very interesting phase between, and all of us have been in this industry for so long, have seen this over the years. On the one hand, the specification of the type of materials and workmanship to be used, and screws and all the rest of it, on the one hand, as against the grand build me something nice. And I think that the August 1st is going to mean you're much more at the here is the description of the material, here is the description of the fixings, the cladding, etc. All of it prescribed, having been checked and approved, and clearly established in the contract and technical documents, and people not just thinking, well, it'll be all right in the night.
Yeah, I think your point about the substituting materials or equivalents or so-called equivalents, that's going to go.
Gone.
Yeah, yeah. Discretion is going to be gone. I mean, architects, sanctioning or giving the go-ahead, even though it might be a lower cost product, often inferior, it's gone. Yeah.
Yeah. Great. Thank you, Simon and Paul. The other sort of category of questions that have been coming in have been around the golden thread, as I think we might expect. As Simon, you said earlier, I think we can expect to see another session here, full session about the golden thread. I don't know if the audience is aware, though, that about, I think it was on the 21st of July, wasn't it, Simon, or at least a week ago, the Building Regulations Advisory Committee Golden Thread Working Group produced a report. I think that's where a lot of your that one particular slide came from. Because we don't have time at the minute, I'm just going to post in the chat here where you can find that report. And they give this sort of 10 golden thread principles. So I think it's a watch this space as to what the golden thread is going to look like. But I think when it comes to data and you use terms like secure, accountable, relevant, and proportionate, I think there's a lot to be discussed around that. Clearly not one for now. And just finally, we've got a lot of questions about, will this recording be available? Yes, it absolutely will be available on our website along with the slides. And
try and match up the talk with the slides and see how well you do.
Good luck to everyone. But I think we're going to wrap that up. We will try to get back to you on some of the questions that you have sent in. Thank you again for sending them in. And Simon, Paul, thank you very much for taking us through this.
That's a pleasure. Just one thing, I've got a message on my mobile saying we should do a webinar on building safety cases and what they mean and what documents need to be prepared in relation to getting one, which I don't think anyone knows the answer to strictly.
That's why I need a good webinar. That's why I need a good webinar.
We'll see you back here again, shall we, Paul? In a couple of months.
Sometime soon. Good to see you all.
Great. Well, let's just wrap it up here. Thank you very much to our audience for joining today. Please do join us next week, where we will be discussing net zero legislation, technology, enablers for change, and you will have myself, fellow partner Jeremy Glover, and Paul, you're Ruth Keating from 39.
She is an extraordinary talent. She and I did a webinar last week on the chapter on damages that she helped edit in Wilmot Smith on Construction 4th edition. She is a total star. She made me feel thick.
We're very much looking forward to welcoming Ruth. So please do tune in, same time next week, Thursday, 12 o'clock. And we hope very much to see everyone back here again. Thank you again, everyone. Paul, Simon.
Thank you.